Hello, everyone. I'm very excited and pleased to be here this evening and to have a wonderful panel to join us. My name is Maron, and I am the Acting Executive Director of FAIR, the Foundation Against Intolerance and Racism. And I am here with some friends of FAIR that I would like to introduce now to all of you. First, we have with us Ilya Shapiro. Ilya is a Senior Fellow and Director of Constitutional Studies at Manhattan Institute. Before that, among many other things, he was the Vice President of the Cato Institute and the Director of Cato's Robert A. Levy Center for Constitutional Studies and the publisher of Cato's Supreme Court Review. Ilya has also testified many times before Congress and state legislatures and has filed a rather incredible number of friend of the court briefs. I believe it is over 500 before the Supreme Court. There are many.
Filed is the key word, not written.
Yes. Okay, filed. There you go. And is also very accurate, which is a wonderful thing, and someone who's going to advise us about constitutional law. And I will also add, quite wonderfully, that Ilya Shapiro is a new FAIR member of our board of directors. So welcome, Ilya. We have Wilfred Reilly with us as well. Wilfred is an American political scientist. He is currently an assistant professor of political science at Kentucky State University and the author of several books that I can personally recommend to you because they're all great. He is the author of Hate Crime Hoax, How the Left is Selling a Fake Race War, and Taboo, 10 Facts You Can't Talk About, and the $50 Million Question. He is a Kentucky, well, I will also say about Wilfred that he is also connected to FAIR. He is a FAIR board, a long-term FAIR board of advisors, and we're thrilled to have him here this evening. Welcome, Will. Wei Wah is a personal friend, and she is also an adjunct fellow at the Manhattan Institute. She is the founding president of the Chinese American Citizens Alliance of the Greater New York, or CACAGNY, as we say here in New York City. Wei Wah and CACAGNY are currently suing New York City for its anti-Asian discrimination in admissions to the specialized high school. She has been a long-standing advocate for merit-based admissions and for high-quality public school education. And Wei Wah is a friend of FAIR, I think I can fairly say. Welcome, Wei Wah. So I'd like to jump right in and get started. And I thought what we would do, since we do have a constitutional expert with us this evening, is that I would take the first question to Ilya and ask, we have people of various degrees of knowledge and information and background that have signed on to this webinar. Could you share with us, Ilya, what was the law around college admissions before this ruling came down? Could you give us a specific example of how affirmative action was allowed or how it was used so that we can then talk about the changes?
Sure. In 1978, in fact, 45 years and 1 day ago, the Supreme Court decided in the case of Regents of California versus Bakke by a one-justice vote that higher educational institutions can use race as one of many factors, never determinative, to enhance in the interest of advancing educational diversity. On that one vote by Justice Powell, there were 4 other justices who would have excluded the use of race altogether, and 4 justices who would have said, yes, you can use it however you want to remedy America's long sordid history regarding race. But no, Justice Powell, the deciding vote, said you can use race in a limited manner, one of many factors. 25 years later, in the University of Michigan cases, Grutter and Gratz, in Gratz, the Supreme Court threw out the mechanical application of race using just a set number of points or quotas. But in Grutter, involving the law school, said that, yes, indeed, as Justice Powell said, you can use it as one of many factors in this holistic evaluation, never determinative, individualized review, that sort of thing. And curiously, in the majority opinion by Justice O'Connor, said that she expected that in about 25 years, we no longer need this, that it will kind of fade out by itself. Well, we're 20 years past that now, and it's certainly not fading out. And if anything, that one seed of the diversity rationale by Justice Powell blossomed into this whole tree of the DEI apparatus that we see now. And the issue before the court this year that they decided today was the use of race in these holistic evaluation programs by Harvard and UNC, the oldest private and public universities in the country, respectively. And curiously, Harvard had actually invented holistic admissions review to exclude Jewish applicants back in the 20s and 30s. So, what's new, what goes around comes around, I guess. And what has come out in this litigation is that the use of race, regardless of whether you think it's a good idea or for what reason, is anything but a one of many non-determinative factor. In fact, it's determinative for most Black and Hispanic applicants to Harvard, for example. The statistics are rather damning in terms of at any given level of academic achievement, GPA and standardized test scores, your chances of getting in are drastically different depending on what race you are. Similar dynamic at UNC. And so in the end today, the Supreme Court ruled this was not a compromise or wishy-washy opinion. Chief Justice Roberts, writing for 6 justices, it was 6-2 in the Harvard case, 6-3 for UNC, because Justice Jackson, the rookie justice, was recused from Harvard. She had been on their board of overseers. So the 6 justices, writing through the chief, said that no, using race in admissions violates the Equal Protection Clause of the 14th Amendment. You simply cannot do it, full stop. Rather thorough but concise 40-page opinion. That counts as short for big issues at the Supreme Court. There are a total of 237 pages. And I'll admit to you, Maude, that even though it's already 6 p.m., 8 hours past decision time, I have not read every single word of those 237 pages.
Well, I can admit to the same thing, but I did read all of Chief Justice Roberts' opinion. And it was a pleasure to read, I must say, because apart from agreeing with quite a bit of it, it made its case very clearly in a way that I think, if you believe the polling, that a great deal of Americans actually agree with. Americans across, depending on how poll questions are asked, of course, you always get different answers, but Americans across every racial group have expressed, when asked clearly about not using racial preferences to determine admissions, that they actually agree with Chief Justice Roberts.
And Maude, one more thing on that. If the viewers do want to read Chief Justice Roberts' opinion, I mean, it's 40 pages, so it's long for non-lawyers, but it is clear. He's probably the best writer on the court, he and Justice Kagan. But if you want to, that's to learn what the actual law is. But if you want some more history and some fire and some passion, go back and forth between Justice Thomas, who's wrote a concurrence, and Justice Jackson in dissent. They are just having at it, and they also happen to be the only 2 Black justices on the court. But a lot of interesting stuff there. But as you said, Chief Justice Roberts' majority opinion, no nonsense. And it's very clear, and obviously colleges and universities are going to try to look at workarounds and what have you, but I don't think there's much wiggle room there.
Right. I'm going to come back to what you just said about workarounds. It's one of the questions I wanted to ask going forward, but before we get there, Wei Wah, I wanted to turn to you and ask you what is more or less a non-legal question. As an education activist and community leader, would you say that today has been a day of celebration or enthusiasm among the various education communities that you have been part of?
I first want to admit, too, that I have not read the entire 237 pages, but I can encourage people to become Supreme Court follower junkies. The writing is extremely interesting, especially for people who don't see it as just a legal document. There are real issues over here. It's not a boring, dry document, but it says a lot about where we think this country was, is, and should go. So this is a day of, we think, of triumph. Not the final triumph, because we're still not there, when we still have a lot of people trying to think about ways of skirting around it. That's not really what we should be thinking. We shouldn't be thinking about how to look at ways not to follow the Supreme Court ruling. We should not think of this as we're going back to something that's bad. No, we're overturning bad precedents that have been at play for the last a couple of decades, more than a couple of decades, because when Bakke and Grutter were ruled, these were actually admittedly flawed decisions. The justices knew, they agonized over and said that, gee, do we really have to do this? And they knew what was wrong. It's sort of like saying, well, this is a little bit of poison. And Powell knew that this was poisonous, that when you try to have people look at themselves, differentiate themselves, be chosen, being judged as their race as opposed to their achievements, that's a problem. You know, race is an attribute. It is not an achievement. You don't achieve something by being of some race. You achieve something by doing something with your abilities, with your talents, and your interests. But what has happened today, I think, is going to be significant. We do know that the universities have a huge stake in trying to keep alive their narrative. They have a huge DEI divisions. The University of Michigan has, for their DEI division, has 8 pages in the org chart. And I think 8 pages of an org chart is just humongous. You've got 200 people floating around, and they have an interest in trying to make sure that they continue to find ways to skirt around this. And so we should be on the lookout for that. We know that this is a significant win, and we have to thank SCOTUS. We're looking at the law, looking at what is good for the country. We're also thankful for what SFFA and Edward Blum have done, because it's not just about Asians. I can talk as an education activist that is devoted to the equal rights of all the students. And yes, it happens that right now, Asian Americans are particularly targeted, but that has not always been the case. At other times it was the Jews, at other times it was other groups. There's no group in America that has not suffered some sort of discrimination, and even at the highest levels. I could still remember reading about Kennedy, that this was an amazing thing that he was a papist because he was Roman Catholic. We are looking at a different time and a different world, and to be able to say that we can judge people by their own abilities, that is a significant win. Now we have to go and focus on how they're going to get around it, and I'm sure that that's something we're going to talk about going forward.
Yes, indeed. That is one of the things I wanted to talk about. But before we get there, I wanted to speak to Will, who is currently a professor who has students on campus. And I wanted to ask you 2 things, Will, and that was with regard to your students now and the students that are on campus. Have you had any chance to sort of, take a temperature on how fellow professors, your students are reacting to this? But more, more particularly, I wanted to ask you, how do you think this will impact your college campus and other college campuses as this goes into effect? And in a few years, do you think you'll have a different looking campus?
Well, without being glib, Kentucky State is a historically Black college, and we're about 65 to 70% Black. So, I mean, even if more good Black students are on the market, I don't know how dramatically that could impact us. I've had a few conversations about the decision, and I mean, most academic professors and most college students tend to be pretty conventionally liberal. So, I mean, everything was politely phrased, but the general language was along the lines of they don't want minority students at these institutions. I personally find that argument bizarre to the point of ridiculousness. I.e., the claim essentially is that if you don't favor large boost enhancements for people in certain groups, you're racist against the members of those groups. And I don't think the logic there really holds together. But yeah, a few casual conversations. Of course, it's the summer, so the majority of our students aren't here. Right. In terms of how this will affect colleges across the board, I think it's going to have a pretty significant, well, there are 2 possible options. And Wei Wah talked very frankly about one of them. I want to touch on this too. But I mean, assuming that race has been pretty much effectively removed as a factor of consideration during application. And I mean, I pulled up some of what Robert says. Both of these programs and most programs which place significant weight upon the variable of race lack sufficiently focused and measurable objectives warranting any use of race, unavoidably employ race in a negative manner, involve racial stereotyping. I think a very significant note here, lack meaningful endpoints. So, I mean, if we just stopped considering race, the simple reality is that you'd see a dramatic shift in where people are going to college. Right now, and I don't know if a lot of laymen know this, there are essentially 3 different student body pools when it comes to SAT scores. So, I mean, Hispanic students, last I looked, were at 964 mean on the SAT, Blacks 941, Natives 926. So you've got this clump around 950. You've got whites around 1100 very consistently. They've been above 1050 for a while, but generally below 1120. And then you have Asians at almost 1250. Last year, after the COVID impact, the Asian mean was 1229, which is the lowest I've seen it in a while. And I'm not joking when I say this. Apparently, some Asian parents were quite disappointed by this low performance. So, I mean, if you just allow all 3 groups to compete fairly in terms of application to every school, you're going to see something very different from proportional representation. You're going to see something that might look a lot more like the NBA, where an elite STEM school like Caltech, which actually doesn't practice much affirmative action now, might be 55% Asian and 21% Jewish American or something like that. So what would that do for the students that are currently going to Harvard with, say, a solid 1270 SAT as African American male? Those students would be going to Michigan State. I mean, it would be that simple. Assuming that this all takes place as people seem to be expecting that it will, those students would go one step down the ladder. Instead of going to number 12 nationally, you'd go to number 73, just as, you know, white kids have been doing for a while. And I will say one positive aspect of that is that you're much more likely to graduate with a useful degree from number 73 than from number 12 if you're going in with the 1270. I mean, there's an entire book, Mismatch, that I would recommend to every viewer here that discusses this in some detail. You see a phenomenon with affirmative action where people that are actually quite well qualified objectively against the overall student applicant pool will go to MIT, just get slaughtered and end up dropping out or moving into what you might almost describe as useless majors, the studies to the extent they exist there, so on. But I don't want to use up everyone's time. I will say one more thing, though. We're all assuming that the rules are followed as the justices outlined them, and I would not assume that. At all. Yeah. As a tenured professor who's been an executive in higher education, I think I see Ilya nodding a little bit. I mean, so there's a loophole in the case where they say, at least at the level of an individual application, students could simply demonstrate that they have been impacted by racism. So, I mean, that's just a shift one step over. You're not a member of race X. You're a victim of racism Y. So I think you're going to see Black and Latino students very explicitly outlining some of these experiences that they may or may not have had. Another thing that you're going to see institutions doing is simply dropping standardized tests. So if you're using grades, and this is like a group chat with academics as of today. I mean, if you're just using grades to admit students, the grades for African-American women are actually quite good. And, you know, kudos to that group. But you could simply say we have proportional representation because the students we're admitting have the best GPAs. Are you looking at quality of school? Are you looking at standardized tests? No. But I'm curious to what level we see compliance.
Right.
One thing, I have something on that, but the mismatch point, I just wanted to, you know, Will laid out this phenomenon that, you know, if you're admitted, then there's clustering of these people who get racial preferences towards, or anybody who gets preferences for that matter, you know, the hockey team or whatever, towards the lower quartiles or what deciles of achievement, of academic achievement on campus. But another, which hurts graduation rates, bar passage rates for law schools, when you're all of that sort of thing. Which is why you have, you know, disproportionately more Black doctors from HBCUs and that sort of thing. But culturally speaking and politically speaking, that mismatch has, I think, exacerbated our debates, our toxic culture with respect to DEI, with respect to all these things, because if you have that clustering in the lower achievement quartiles and everyone's looking around, it's like, oh, it's, you know, mostly Black and brown people who are not achieving well here. This place must be racist. We need to change the structures, and it breeds resentment and all the rest of it. So mismatch, you know, is just such a nefarious thing beyond even the graduation rates and moving to less rigorous majors and bar passage rates, et cetera.
Yes, and
Sure.
you have all three of you now touched upon what is the next question I want to ask you about. And I will set it up like this. I had a friend of mine who's I won't call out the university that she was receiving her alumni mail from, that sent an email in response to this decision that said, you know, in all the alumni fluffy language, expressed concern about the decision, and then said, and I'm quoting, "We will respect the law, but," and I thought, oh, that's always a tricky way to start a sentence. And after the but came a commitment to the beliefs of diversity and equity and initiative. But it got me thinking, something that you have all referred to already is, how will that look? The decision itself explicitly calls out that a student might talk about their race in a way in which it impacted them individually in an essay or in some other form. Do any of you have any thoughts to how else that might look when colleges and universities seek explicit workarounds to this?
Let me just give you the legal standard that Roberts gave, because Will did, and you just summarized that sentence that's key, the loophole, as it were. But he follows that sentence, Roberts does, the majority opinion, with, but despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime we hold unlawful today. Parens. A dissenting opinion is generally not the best source of legal advice on how to comply with the majority opinion. So he's fully aware. They're not dummies. They know this whole debate. They know the questions people are asking and the resistance that the educational institution establishment are going to bring. And I mean, there's still room for mischief from lower court judges in this follow-on litigation that we'll see. But I think it's pretty clear that he's like, individualized treatment. Yeah, if you want to talk about adversity, if you faced racial discrimination, that's consider that just like any other kind of adversity. But if at the end of the day your stats look exactly the same, coincidentally, that's not going to pass muster.
Yeah, I mean, I think that the thing I would say about that is a case needs a plaintiff, to use the old cliche. I mean, there could be years of ducking around this, and I'm certain there will be. I think that I do think that that's a valid point, at least in the 5 to 10 year short term. I mean, if institutions simply say, well, we happen to notice that in this white supremacist society, almost every one of our minority students scores more highly on the structural suffering scale that was recommended to us by our psychological expert, Dr. X. That's something that would then be litigated again, and it would have to make its way up to the Supreme Court and so on down the line. Maybe the horse will learn to sing. I think that the more serious threat, though, would simply be the second line there, that something like 30% of American universities now no longer require standardized tests. So I think in that context, it actually would be fairly difficult to demonstrate that race was a factor. If a university were to say, and this is to some extent off the top of the head, it's not something I've extensively researched, but if a university were to say, well, we are admitting students on the basis of GPA, extracurricular activities, commitment to diversity, or whatever else, and the students that score the highest on this very objective scale that we're willing to provide to the courts happen to be probably a little below the national representation, but the 11% Black or something like that, you'd have to challenge that and very specifically prove that there's something wrong with that means of admitting students. So I think there's going to be a lot of resistance to this.
I think Will is right on target there. Getting rid of standards is one of the best ways of hiding, of burying the evidence. And so everybody knows that if you could tamper with that, or you could just tamper with the test too. What you do is you say, we'll keep a standardized test, but we're only going to test what is extremely simple so that everybody comes out with essentially 100% on their scores. You know, if you test only 1+1 as opposed to trigonometry, everybody's going to pass the 1+1. You may not make it to the trig, but if you do that, then you can effectively disregard that, bury the evidence, and do whatever you want again on other ways of looking for these race proxies. And some of the race proxies are going to be your socioeconomic factors. So social is a real problem that I think people should focus on, that because it's highly manipulable. You can manipulate the social part of it so that it can be designed so that it takes as many of one race and excludes another race as you wish to design. And that social and zones where you live your zip code type of decisions, holistic measures. You don't want classical pianists any longer. Get rid of those. Those are some of the things that are easy to do, and they will do it. And we've heard it.
In the directly addressing everything that the three of you have just referred to when discussing what universities are doing right now, Chief Justice Roberts, I liked the turn of phrase where he described their use of race as inescapably imponderable. And he said that universities' main response to the objections and concerns raised was trust us. And along that level, I know no one can answer a what if 100%, but let me ask this. If Harvard and UNC had put an end date on their use of race as a plus factor, would today's decision have been different? And Ilya, I'll go to you on that.
Hard to tell, because there'd have to be, presumably they would make plans, gradually to wean themselves off it, rather than just, we're doing this and then a sharp break. If indeed they were engaged in a good faith sunsetting or what have you, the statistics would be different. The whole nature of the case would be different. It might not even have gotten to the Supreme Court. It's a hard counterfactual to see, but certainly since the schools weren't even close to admitting that there should be an end date, and indeed Justice Sotomayor in her dissent said that the end can only happen when there is no more racial inequality, which means never. Then it would be a completely different world. The court wouldn't have gotten to it.
So we are just halfway through the hour. But we have an active and engaged viewership. So I am going to go to some questions, and they have directed some questions to our panelists. So a question for Will. I'm reading this question. How does this jive with the realities of inequities in terms of access and opportunity that we know exist along racial lines?
Well, I guess the question is or the response would be from kind of the center right. We don't really know those exist along racial lines, unless you're using race as a very broad proxy. I mean, every time there's been a serious attempt to look at the Black students that matriculate into the Ivy League or my own Big Ten, I mean, we found that about 2/3 of them, well, combined, about 3/4 of them are either biracial or are sort of foreign lords. They're the children of people from essentially successful Black countries: Bahamas, Jamaica, Nigeria, Ghana, Botswana. I mean, so these aren't necessarily the children of, South Central Los Angeles and so on. So if you're arguing, is there some kind of structural force that's holding back the child of a West Indian dentist versus the child of a Kentucky Caucasian dentist or a Jewish American dentist? I mean, I think you're back to just systemic racism and gibberish. And no, I don't really think so. And this again is one of those obvious points that everyone makes in this debate. If you're really worried about class, just have class-based affirmative action. I would support almost pure meritocracy. I'm sure we'll get back to this, but I noticed legacy programs weren't affected by this decision. Of course, that wasn't a question before the court. But, I think an even more serious issue would be, what is it? In Kentucky, it's often called FCS, faculty, coaches, and staff. But you get an advantage that's on par with the Latino, if not Black, student applicant advantage if you're the child of anyone that works at the school. That would now include the 108 diversity deans, or whatever Wei Wah pointed out they have at Michigan. The athletes, 8 to 10% of the typical Division I college campuses made up of people to do things like row crew. So there are all of these different things that come into play in terms of who gets in. That's not necessarily fair. But if you really want to talk about, I'm sorry, I got lost in kind of a ramble there. If you really want to talk about affirmative action along class lines, it would be pretty easy to simply look at family income, require a tax form, something like that. And I will note, nobody wants to do that at all. What we've had right now, in my opinion, with affirmative action and legacy programs was actually a bit of a compromise between the white and minority elites, where everyone kind of understood that the Black children that were going to Harvard were not typical Black Americans. The flip side was that the Caucasian children, very often of people that would be friendly with those atypical Black Americans, also got to go to Harvard. And one of those other exempted categories. But basically, if you just want to if you want to give an edge to smart poor kids, which would advantage a lot of Black and Latino kids, you can do that. One of the problems with that is it also advantage a lot of Asian and poor white kids. And for some reason, that's considered a serious objection to that policy.
I agree with you completely there. I think going as close as we can to meritocracy is the best thing for both the child, the student, as well as society. What you do by manipulating on these racial set-asides or these group set-asides, to a certain extent, I'm not a faculty member, but that's sort of like an employment perk. So I can sort of understand that. I don't see it so much as and how many that it's true that there are certain departments that will have too many people in them, but typically if you're talking about faculty brats, they may actually appear more often in a college because they have both the nature and the nurture. If you were growing up on a campus environment, it is not impossible that you actually hit a couple of more books than some of the other people. But I think that if you want to do economics, pure economics, I can understand that. It's the social part there that you can manipulate. It's the part that you said that people don't want to show, that pure economic part that they don't want, because as you just said, a lot of these schools are getting the quote unquote wrong people in. At Harvard, you have 2/3 of all of the Black students there being from either foreign or wealthier populations. And so it does not serve the myth that we are out there helping somebody from the Black Harlem, East New York. That's not happening.
I am going to I have the next question I'm going to ask makes it quite clear that we have some folks who have paid very careful attention to the court and the justices. So Ilya, I will lean on you again, and I will direct this one to you. As holding the previous position of Dean of Harvard Law School, do you believe Justice Kagan should have recused herself from this decision?
It's a tough call because she hasn't been Dean of Harvard Law for 15 years or something. It's a tough call. She was clearly implementing or responsible, overseeing the Dean of Admissions there. On the other hand, the case was, I don't know. I'd have to look at what comparable situations were when someone occupied a previous position, but it was a long time earlier. I don't have a quick yes or no question. It's possible. Yeah.
Well, congrats to our question asker for stumping Ilya or having a question that Ilya needs to think more about. That's great. Let me ask you one more slightly wonky question, Ilya, that we have in our chat. Could you comment on how the ruling could be applied differently between public and private higher education?
Well, the current jurisprudence says that there's no difference in the applicable legal standards for public schools and for private schools that receive federal funding under Title VI of the Education Act, of the Civil Rights Act. Chief Justice Gorsuch wrote a concurring opinion that says that not only are the practices at issue, the use of race in admissions, unconstitutional, but they also violate Title VI. But we don't have that kind of separation. And so if some schools are so dedicated to the use of race in admissions because they believe in diversity or for whatever reason, they could always decline federal research grants, student loans, and all the rest of it, and have a lot more leeway to pursue those kinds of policies. I don't think anyone's prepared to do that, but maybe. But for the time being, there is no difference, and it's because of those strings that are attached to the federal funds.
I also noticed in the decision I think it was a footnote that exempted military academies and said that it was not, wasn't a question before the court. But I wonder if anyone here thinks that under the strict scrutiny and that the judges might find that there might be room to find a different decision than they do with regard to colleges. Certainly, and I remember reading an armed forces brief in favor of affirmative action decades ago, talking about how important it was when you have a situation with officers and enlisted men and women now, that we don't, that wasn't divided on clear color lines. Do you think that's an area that might be different, or do you think the court's decision was so strong with regard to not using race as a factor that decisions in other areas like military academies would be the same as this one?
A different interest, so it's unclear how it would come down. There were no other interests other than diversity rationale that we've been arguing over since Bakke in 1978. In this case, military academies would bring those kinds of arguments that you talked about in the military brief from the Michigan cases from 20 years ago. And they would say, for our national security, we need a diverse officer corps to oversee the enlisted men who are more diverse, and all of that sort of thing. So unclear how they would ultimately decide it, but it would be a different kind of briefing situation.
And I have another question from our chat asking, is there any recourse? And I throw this open to anyone, to Wei Wah, to Will, to Ilya, anyone who wants to answer this. Is there any recourse for students who have been discriminated against up to today?
I think for the ones who just recently got discriminated against, you can reapply, right? You could reapply now. If you're not a senior in college, you can apply to transfer and see how you're treated. And if you had stellar grades and you've been doing well, I think you'd have a good case to say that you should be admitted into the college that discriminated against you. If you were discriminated against 30 years ago, I think that that's a different matter. I think that you won't have much of a case there.
I mean, I personally think you'd have almost no chance. I mean, not only is, as far as I understand, all criminal and civil law not ex post facto, it's forward going, that you'd also have to prove that you specifically as an individual applicant were discriminated against on the basis of race under the previous standard. And that would be very difficult to do. I mean, if you're looking at the Ivy League, what we saw that was so striking that I think we've all seen even online was kind of the broad ranges of scores in terms of how they applied across groups. So, I mean, if you were applying to Harvard Med as an Asian student with one of the best possible scores in the country, you had whatever it was, a 26% chance of admission. As a Black student with the same score, you had 100% chance of admission. So that was striking. But at the same time, I mean, there were a very large number of students at the highest level of performance in that case that didn't get in. And that was true across, 2 to 3 of the 4 major racial groups. So you'd have to show that you were stopped because of your race and not something else. I don't see how that argument could be successfully made in most individual cases.
And speaking to that point, Will, the proponents of affirmative action have often said that affirmative action should remain in place because in its absence, universities will see a dramatic decline in Black and Hispanic students. With regard to how the justices addressed that point, the dissents were rather robust. And as Ilya said, Justice Jackson was quite strong in defending affirmative action. Did you think there were any points in the dissent that needed to be addressed, or anything that was in the dissent that you thought was points that would be that are going to be adopted generally as people talk about this case?
Well, I think the key point of the dissent is, a point that's been made in the academic literature by people like Espenshade for decades, that without affirmative action, there will be a level of minority drop-off at the very top colleges that most people do not expect and probably aren't prepared for. I mean, if you actually look, and the data I have on this is fairly dated, but if you actually look at the number of African-American graduating seniors each year that achieve the SAT score that's typical for a STEM student at Harvard, 1550, let's say, you're talking about maybe 700 people in the whole country. And again, the Asian American average right now is around 1250. So, without any affirmative action programs whatsoever, even Harvard in the fair admissions case estimated that, someone might correct me by a point or two, but 60% of their Black students, 49% of their Hispanic students wouldn't be there. And I think that's a dramatic underestimate. If you just look at test scores and GPAs relative to the rest of the student population, it'd be closer to 94% and 85%, something along those lines. So, I mean, that is a valid point to make. Right now in America, we're very committed to this idea of proportional representation. There are scholars like Dr. Ibram Kendi who will argue that any gaps in group performance against any metric indicate racism, which is, of course, nonsensical. Variables like study time vary wildly across groups and so on. But I mean, I think that a lot of people, if they were, let's be real, if a lot of people were to look at a Harvard, if a lot of people were to see a Harvard that was 50% Asian American and 1% Black, and by the way, maybe 30% Anglo-white max, I don't necessarily think they would be enthused about that, or that they would find that the result that they'd expected. There is a very real response to that, though, which is that unless you're a genetic hereditarian, you should expect it to be possible for minority students to improve on their current performance. So hopefully this will start a real conversation where, instead of people saying as sort of an upper middle class cliche, well, of course, Black students can't do any better than that, Erica Marsh today, there's ghostly racism out there in the system, you could start noting things like the fact that
that's
Black
not
students,
a parody account. I was kind of taken aback by that tweet.
I'm pretty sure it's not.
No.
Maybe it is. I mean, it's a
Just-
former
It's hard
Obama
to
stick.
Just
tell
amazing. I
these
mean, the
days
tweet
what's
was
a parody
basically
account.
saying in a merit-based system, Blacks can't compete, and so we need affirmative action. It's just breathtaking.
Well, I mean, Erica, I will say, to be fair, Erica Marsh and Saira Rao are the two that are right on the parody line for me. I can never tell. But I mean, you saw comments like that throughout kind of the Twitter and Instagram verse today, where people are kind of unintentionally telling on themselves, where people were saying things like, how can they compete now? What can they possibly do? And you saw Black businessmen like Charles Love, my broadcasting partner, responding like, do you think we're all idiots? We'll hit the books a little more. But I mean, the basic reality is that right now, Black students study about half as much as white students, and white students don't study a lot. I mean, it is to be hoped that that improves for both groups of students if they have to seriously compete with Indian American, Nigerian American, Chinese American, so on, scholars. So that is the outcome that no one's talking about, that an SAT of 950 just isn't that good. And a 1050 for native born American whites isn't all that great either. So perhaps there is a solution other than proportional group preferences forever.
Will, the numbers that you referred to, and what might Harvard look like if this is a completely merit-based Harvard and other schools look like if this was a completely merit-based admission system, is in fact what we see here in New York City in specialized high schools. So it is one of the few places that I know of that have a straight merit-based admission system. And we see those numbers, and we, those of us who live in New York and advocate for merit-based admissions, we say, oh, it's time for the 7 Black students in Stuyvesant article, because the New York Times and every other left-leaning liberal outlet writes the same story again and again. What they don't write, to our great frustration, and which we try to highlight, and this leads me to a question that's in the chat. The question in the chat is, to what extent can better outcomes in the K-12 make the ruling today more or less obsolete? And I will just mention that Wei Wah and Will and myself were in the Bronx a few nights ago at Vertex Academy, a charter school started by fellow FAIR Board of Advisor Ian Rowe, listening to a conversation about agency versus equity. And one of the things that Ian Rowe was pointing out is that, and Will, you're going to have to correct me if I get it wrong, it was either 7% or 9% of students in that district were graduating high school college ready. And that means there's a certain number of students who just don't graduate. But even the students who are graduating, when they go, if they matriculate at a city university, are having to do remedial coursework to get themselves up to the level of college preparedness on their own dime too, which is very frustrating. So the question that's being asked is really, what are we going to get to better outcomes, and can we create better outcomes that would make this ruling today obsolete, so that we could stop the pressure on race-based remedies because we had other remedies? Is anyone that hopeful that they want to offer?
I mean, by the time you get to college, it's too late. We're using the wrong tool to remedy other social ills. You know, nobody's saying that, you know, everything's hunky-dory and we live in a utopia, you know, whether it's K-12 education or family formation or, you know, issues with criminal justice or anything else. I mean, you're using a hammer not to go after a fly, but to, you know, peel an orange or something just completely, you know, heterodox to the issue that we're facing. admitting more mediocre kids of Black doctors or something is not going to remedy the ills of the underclass. So that's not exactly the question you were asking, but it just seems like the public policy tools need to be a little more parsimonious.
I think Ilya is right on the mark here in talking about perverse incentives. We should be thinking about incentives policies that will make sense for the education at an earlier level, the family formation. One of the things that came up was that in 80% of the households in the community that we were visiting at a school there were a single parent households. And we know what sort of impact that is. And we also know that if colleges signal to the communities that you do not have to work harder because you're going to get a bump up because you're going to get admitted because of what you happen to be, what your attribute is, and not what you do, what your agency is, what you work as, then there is no incentive to really change earlier the K to 12. Why should you? See, so actually we should hold the colleges responsible for some of the dumbing down of K to 12 for these sectors. We should hold everybody to high standards. And you see that happening. You see that happening in the charter schools here in New York City, where 23 out of the 25 top performing schools in the standardized test for math, 23 out of the 25 are all charter schools, not the public district schools, and they are mostly Black and minorities. And so it can be done, but you have to change the incentives and say that we keep to high standards for everybody, and you do not have affirmative action there.
No. I have two more questions that I'm going to go to in our chat before we go to some final statements. This one I will ask, and anyone who wants to answer it can, but how does today's decision align with SCOTUS decisions from the civil rights era? That's a pretty broad legal question.
Well, it's sort of the closing parentheses on Brown v. Board, which was discussed by both John Roberts in his majority opinion, Clarence Thomas in his concurrence. This era of, first, that ruling, Brown v. Board, didn't actually affect desegregation. It wasn't until the Civil Rights Act, subsequent rulings, and bringing in federal troops and what have you that accomplished that in the Deep South. Similarly here, this is not the end. It's probably the end of the beginning over the legal fight. There's obviously more policy skirmishes and whatnot, but this is it's basically saying that, look, we let this go, we let this fester, we've created what we've created, and it's part of the larger debate over DEI. And I'm writing a book now about the illiberal takeover of legal education. I think this, among other things, is part and parcel of that story. But it's at the end of the day, so many Americans have already been, at the time of the Michigan decisions, but even more now, ready to be done with a system where people are evaluated based on their race, not because they're okay with existing inequality, but because they recognize that injustice done to particular individuals who did nothing to deserve it is bad, and there's other things that we should be doing in society.
Yes.
Yeah, I mean,
go ahead,
just
Will.
as a comment there. I mean, I suspect we're all probably going to agree on a lot of this, but to me, this decision, and not to me, I mean, if you look at the legal structure of this decision, this is very consistent, with what I think most people think of as the spirit of the civil rights movement or of the civil rights cases. Basically, the core theme that most people associate with, for example, Dr. King, although he himself was a complex man who wasn't always consistent along these lines, but is the idea that you shouldn't treat people differently on the basis of race. So, I mean, when you see a decision that says you shouldn't treat people differently on the basis of race should be either a marginal factor or a non-factor. I think those are the two options in collegiate admissions. The large majority of Americans are going to agree with that and feel that that's consistent with that legacy. I think that's very fair to say. And by the way, that's what the data shows. I mean, more than 53% of every group, blacks at the low end there, but well over half of every American population group opposes affirmative action if you define it accurately. If you define it as any advantage in test scores, grades, et cetera, for any racial group, not do you want to help minorities or something like
Yeah.
the gender affirming care of the race debate. So, I mean, yeah, I think that obviously the answer is yes, getting to the point. What Ilya could probably point out in better detail than I could is that we've taken a long detour with the AA cases. Technically speaking, the rule in law is that you can discriminate if a standard known as strict scrutiny is met. The discrimination is absolutely necessary for a critical state objective, so on down the line. Diversity has been held in a number of cases to be one of these. And I mean, I haven't been in the courtroom for years. I'm sure my language is a bit off there, but diversity has been held to be one of these standards, one of these things that's absolutely critical for a smoothly functioning society. And a lot of political scientists looking at that would say, well, I'm not sure that's true at all. And I'm
just
not
as
sure
Thomas says, I still don't understand what diversity is. What are we trying to achieve here? How do we know when we've achieved it? You know?
Yeah, diversity, actually, I will say in political science, diversity is either a true neutral or a slight negative. I mean, diversity just means there are people of different ethnic, racial, religious populations in an area, if you're using any real definition there. And what we find is that has positive effects. I mean, that increases cosmopolitanism. I'm glad to have Asian American friends, for example. It decreases groupthink. That's Japan's great weakness in business. It does boost patent rate, things like that. A common alt-right claim is, the USA is just a money machine as versus Moldova or some such place. But I mean, there are also negatives, massively decreased social trust. We all know them. So the claim that diversity is this critical thing for a society, I mean, I think many Asians, Latin Americans, people in societies without perhaps as much of it would dispute that. But at any rate, the claim that diversity was one of these most critical state objectives has been made for decades now. Affirmative action is almost 60 years old if you date back to the Philadelphia Plan. And I think the courts have said, well, that's 3 generations, that's enough, now it's not. And most people would feel that that's very much in the spirit of, the Freedom Riders going south.
Well, I think that as I read it, diversity was not held to be such a golden goal. It was questionable. It was problematic. And if you did believe in diversity, you still have to think about what kind of diversity we were talking about at the outset. We were trying to get a robust exchange of ideas. So we're failing in that. The other thing is that let me stand here as when we say Asian Americans, that's another thing that was addressed in the documents today in the ruling, that what on earth are we talking about when we say Asians? This Asians is so diverse. When we talk about so many different languages, religions of peoples, histories of people who've been fighting each other. If you just talk about South Asians, you're talking about over 1 billion people here and 1 billion there. And within those countries themselves, they're very diverse. So to paint a picture of non-diversity by saying, well, let's go and take care of these Asians and just put them in a little box over here, that is completely racist. That doesn't even make sense. We're talking about whites and blacks and the more what you call the East Asians. They're all Asians and we're lumped together. And when we talk about
you don't have any Sri Lankans in your family, Wei Wah?
Yeah, I don't believe I do, but here we are. We have so many different people, and this is America. We are going to be very, very diverse just by our interactions, and more families, in fact, are going to be biracial, multiracial. They have found in some studies that there's a lot of claims and wrongly that they all have Native American blood. A lot of whites do claim that, and I think that those are things that we should embrace as part of our unique identities, our unique individual identities. And I want to come back to what we are talking about. We're talking about kids. We're talking about individual applicants. And when we really minimize and dehumanize our applicants by making them primarily a racial instrument, I think we're doing an injustice
I
to
think
our
so
whole
too.
community.
Let me move us to, I
Could I jump in there really
100% agree
quickly?
with that. What's that,
Oh,
Will?
I just said, could I jump in there really quickly?
Sure.
Yeah, another point in the case is just that the races were really incoherent. I think that this is something that's worth mentioning. Like Wei Wah just did a great breakdown of the Asian category. But one of the moral arguments for affirmative action was that blacks were oppressed by whites. And as we've moved forward in the USA and become this very diverse country where Asian Americans are 7% of the population, Hispanics, by the way, not blacks, are the second largest population group, 18%, affirmative action just seemed to make no sense. Why would you discriminate against a hardworking immigrant from Vietnam in favor of a hardworking immigrant from Ecuador? That was something that you can't not notice when you actually look at the plaintiffs in these cases. 75%, 80% of whom are Asian American. Everyone in this case, I believe, was.
Right. So
going back to your civil rights question, though, I found this section in Roberts' opinion where this is quite remarkable. In the dissent's view, this court is supposed to tell state actors when they have picked the right races to benefit. Separate but equal is inherently unequal, said Brown. It depends, says the dissent. So no punches pulled here.
None at all. That was very clear. And thank you for finding that. Let me ask a final question before we move to wrap up. And this is a broad question as well. How do any of you think, or how do you think this decision might impact our culture, legal culture, work culture beyond college campuses? Do you think it will have an impact in the world beyond academia as people, because the DEI industry that Ilya, you have mentioned so often, may have started and been most strong in colleges, but it's seeped out into our everyday life in many other settings. So do you think this decision will have an impact beyond college campuses?
Well, you use the word culture, and that's the thing of it. It doesn't have any legally binding effect beyond higher ed admissions. But given that what we know about, most Americans supporting this decision, if you're just on Twitter all day, you wouldn't realize, or if you're just talking to academic administrators and professors all day, you wouldn't realize. But given that most people like this decision, maybe that will steel the spine of folks, whether in corporate America or responding to local government initiatives or who knows what, to just push back on some of the more radical things coming from HR or what have you.
That's what I thought too, that HR administrators who may have despaired sometimes at what they were being instructed to do from their DEI administrators might, while not legally binding, might like to point to this decision to some extent. Finally, let me say this. Thank you so much to all of our panelists for joining us this evening. I'd like to go to each of you, because we are at 6:59, so we're a little bit late, but I'd like to go to each of you for a 60-second wrap up and to final thoughts as you've had a day to ponder this decision and to share with our wonderful questioners and panelists in the webinar who sent us so many great questions, what you think as this day comes to a close on this very historic decision. Will, can we start with you?
Sure. What I think is that this is this is the end of an era. I don't really have necessarily so much of a moral take as a practical one here. Affirmative action for many years was presented as sort of a moral necessity given the tough history of American race relations. And as America changed, as the country became dramatically less racist, as 2 or 3 generations passed, and as the population changed, so that the USA is now only 62% what might be called Anglo-white, and that's no longer the highest academically performing group, the system that we had in place became harder and harder to justify. So I think you saw a really epical moment here when this group of minority college applicants came forward and said, we were discriminated against in favor of other minority college applicants with lower marks and scores, and there's no way you can morally justify this. My own goal would be that we move beyond this to eliminate the other 5 or 6 utterly non-meritocratic categories of college admissions. And I do think we're going to see the impact of this in the business world as well. Hopefully everyone will begin to compete more fairly, but I will say a lot of people are going to be really, really shocked by what the results of that look like. They often might look a bit like the NBA, just in different directions.
Yes. Wei Wah, can you give us some brief statement?
Thank you. I do have to agree with Will that we're going to face a lot of soul searching and saying, what does this diversity mean? What does proportionality mean? I don't think it's relevant because we shouldn't be looking for that. And we are not trying to design things just by checking a box, by ratios, but we do believe in individuals. And we want to make sure that we have merit, because without recognizing the importance of merit, I don't think we're going to be able to sustain a reasonable culture. And so I have to also thank very much SCOTUS for making a very important decision. This is important, and this is not the end. This is a beginning of a new phase. It is not the end, but there's a lot of work to be done still. But I want to thank them. I want to thank also SFFA and Edward Blum.
Yes. Ilya, can you wrap us up?
I criticize John Roberts a lot for various things. You know, he's known as the squish on the court and playing strategery and all of these various things. But I give him credit here. This, you know, if he died tomorrow, God forbid, this would be his legacy. This would be what he'd be known for. And so I think the best way to conclude this session is to quote him 3 times, concluding with his most epic line from today's decision. First, it's a sordid business, this divvying us up by race. Second, the way to end racial discrimination is to stop discriminating based on race. Those are old cases. And today he added, eliminating racial discrimination means eliminating all of it. So kudos to the Chief Justice. Whatever else happens, his legacy is secure with this. And on the Supreme Court, while we're talking about it, it's interesting. Until today, the whole conversation was, well, this court is not really conservative anymore. What's going on? And Gorsuch is agreeing with Jackson all the time, and she was in the majority in all 3 cases on Tuesday, which is true. Well, the statistics are still going to be the same. They're going to be all over the place. And but the vibe, as it were, after today and after what I expect will come tomorrow, is going to be more of, you know, from the left, certainly trying to delegitimize the court. But John Roberts has done his duty.
As have you 3, as have our wonderful panelists here today. So thank you very much for joining us. And thank you to all the people who have been watching and putting such great questions into the chat. Thank you all very much. And we will, people are certainly free to email at events@fairforall.org, because I know there are some questions that we did not get to, and we would be happy to forward those questions on for you. Thank you very much, everyone, and good night.
Thank you.